If your landlord breaches the terms of your tenancy agreement, then potentially you can take your landlord to court, but you may need to take certain steps before you do so. For example, if you live in a top floor flat and you have a leak coming through from the roof, your landlord will be obliged under the terms of your tenancy agreement to repair the roof within a reasonable time. If the landlord doesn't do this, then you may be able to start a court claim to force the landlord to do the repairs. You would normally need to write to the landlord and try and resolve the matter without taking court proceedings before doing so, and you may also need to get expert evidence from a surveyor. The claim would normally be started in your local county court, and the same process would apply to other repair problems such as a broken boiler or an infestation of mice or cockroaches. Another example of when you may be able to take your landlord to court is if your landlord illegally evicts you. Landlords must obtain a court order before trying to remove tenants from their home. So if the landlord changes the locks or even tries to get you to move out without going to court, you may be able to apply to court yourself to force the landlord to let you back into the property and to also pay you compensation. A final example is if your landlord fails to register your tenancy deposit with an approved scheme. You may then be able to take the landlord to court to force them to pay the tenancy deposit back and also a further penalty payment. As with the repairs cases, you would need to write to the landlord first and to try and agree with them outside of the court process that they would pay you the deposit and the penalty payment, and only then would you be able to start the court claim.